I'll call this Committee of the Whole meeting to order for Tuesday, March 24th, 2026. In the spirit of truth and reconciliation, we acknowledge the town of Edson is located on Treaty 6 territory, the traditional and ancestral lands of the Hinawak, Saulteaux, Siksika, Piikani, Kainai, Dene, Nakota Sioux, and the Otipemisiwak Métis Nations. We honor the knowledge of this land, the elders and youth which gather here, and our ancestors who have gathered here for centuries. Can I get a motion to adopt the agenda for the meeting? Councillor Taylor.
I move that the agenda for the March 24th, 2026 Committee of the Whole meeting be adopted as presented.
Thank you, Councillor Taylor. Any questions, comments, additions? Seeing none, I'll call the question. All those in favor? That motion is passed. Can I get a motion to approve the minutes of the March 10th, 2026 Committee of the Whole meeting? Councillor Holden.
I motion that the minutes of the March 10th, 2026 Committee of the Whole meeting be adopted as presented.
Thank you. Any errors, omissions, or issues with the minutes? Seeing none, all those in favor? That motion is passed. We have no presentations or delegations. We have no bylaws and policies. We'll move on to our business item for this evening. Our Acting General Manager of Community and Protective Services, Mr. Kitlitz, is going to present to us on Planning and Development 101. GM Kitlitz.
Thank you very much, Deputy Mayor Fogarty. I'm joined here this evening with Ms. Julia Darling, who's going to help with any questions that I stumble on or correct me if I get something wrong. So she's here as a support as well as I go through the presentation. So this will be a high-level overview of planning development services in a municipal context. Not meant to get right into every nitty-gritty detail of planning development, which would take us quite a long time to do. But hopefully it gives the new members of council a little taste of what planning development looks like in a municipal setting. For those members of council who've been here for a while, it may be somewhat repetitive, but hopefully there's a tidbit or two in there that might be a learning for you folks as well. So I'll get into it. So generally, planning development services, it's taking into account various council-approved planning documents and policies and bylaws that help to meet the community's growth project objectives. We do this, one of the things that I don't think a lot of people understand is planning and development isn't just about the physical built form of a community. And council will get a little bit of a feel for that when they see a draft municipal development plan towards the end of this summer, beginning of fall. Planning takes into account social, cultural, economic, environmental issues, as well as the physical built form of a community when we plan. So I think that's a pretty important note. We also help out with other departments and agencies to provide advice. So, is this the PDF version? It is. Okay, so animations won't work. That's okay. So you're not going to be able to see any of my fancy animations, so they're not going to work tonight. So what this is trying to depict is typically in a community, there's a number of different tools we use to plan our growth. The Municipal Government Act is the primary piece of legislation which all municipalities across Alberta need to adhere to in administering planning and development services. I'll get a bit more detail about some of that in a next couple of slides. The second overarching piece of document that's used is a municipal development plan. And that's sort of the one that the municipality will adopt to help guide growth, particularly to their municipality. The Municipal Government Act, and I'll call it the Act throughout this presentation. I'll just shorten it to the Act if that's okay. When I say that, I'm referring to the Municipal Government Act. Every municipality in Alberta must have a municipal development plan and must be adopted by bylaw. So that's a must that's prescribed in the Municipal Government Act. So those two things are sort of the overarching top end of the guidance that municipalities will use. And then from there, there's area structure plans, bylaws, zoning bylaws, outline plans that are typically used on the planning end of the spectrum. And this is really where council does most of their work. In consultation with the community, these bylaws and statutory plans, and I'll go into more detail on those in a future slide, are all done sort of on the planning end. And then when we get to the bottom corner of the slide, that's more the development stuff. So that's where your subdivisions come into play, development permit applications, development agreements, building, safety codes, permits, appeals, enforcement. All that's on the development side, and typically, as a general rule, that's mostly done by administration, guided by the work that council and the community does on the planning end. So going back to the Municipal Government Act, Part 17 is where the meat and potatoes are with respect to planning, development, services and functions. The list here, I'm not going to read it all off, but this is some of the stuff that's covered off in Part 17. There is a bit more that's in there, but these are sort of the ones that most municipalities tackle on a daily basis or throughout their year. And it's important to understand that council acts under the authority delegated by the Municipal Government Act and must act through resolution or bylaw. So you hear us talk about statutory plans. These are defined in the Municipal Government Act, and they are the Municipal Development Plan, Intermunicipal Development Plans, Area Structure Plans, and Area Redevelopment Plans. These all require statutory public hearing and must be adopted by bylaw with 3 readings from council. The other one that falls into that same bracket, which is not identified as a statutory plan, but it does require a statutory public hearing, is the land use bylaw. And council is probably most familiar with this document because it's the one that we use quite often. You will see come before you for amendments from time to time based on the wishes and desires of our development community. Some of the other documents that can be contemplated when it comes to growth, and these aren't necessarily our documents, these are just examples of other sort of plans that are adopted by resolution. Community sustainability plans, housing strategies, economic development plans, rec and culture plans, transportation plans. These are all just some other examples of documents that municipalities may use to help guide growth in their community. We also have a number of operational bylaws, I'm calling them here. These are also prescribed in the Municipal Government Act that municipalities must create these by bylaw. We have a subdivision authority bylaw. In the case of Edson, the authority is the CAO. CAO Beverages are our subdivision authority. We have an intermunicipal subdivision development appeal board. This is with the town of Hinton, I believe we share this responsibility with. We have to have a development authority bylaw, which establishes the development officer, which is Ms. Darling, as the authority to render decisions on development permit applications. It also allows the CAO to delegate other staff as needed. And obviously the land use bylaw, which is the one that's probably most familiar to council and the public, which is used daily. Deputy Mayor, if there's questions, I can certainly stop. I'm going to go through this, but if there's certain questions, I'm happy to stop and answer.
Thank you. So if anyone has any questions and they ring in, I'll just let you know. Thank you.
So land use bylaw, again, every municipality in Alberta must adopt a land use bylaw by bylaw. The Municipal Government Act says that the town must be divided into districts, or the municipality, sorry, must be divided into districts. It must prescribe both permitted and discretionary uses in each of those districts. And it must also establish a process for which an application or a permit can be processed through to a decision. Ours does that. It meets those obligations. But I want to focus on permitted versus discretionary uses because this is really where a lot of the rubber hits the road with our ratepayers who come in to make application on their land. Under the MGA, a permitted use is an activity in a particular district that is basically ideal for that district. It's suitable for that district, and therefore the development authority must approve an application for a permitted use as long as it meets all the other regulations within the land use bylaw. It must be approved. So there's no ability for the development authority to not approve a permitted use within a district. At the bottom it says decisions can be appealed by the applicant only. That's a little bit incorrect because the decision is going to be an approval. So there is no decision, but an applicant can appeal a condition of that approval. So there is no decision because we can't say no, but there could be a condition on there perhaps that the applicant doesn't like. So let's say maybe the condition was, it was for industrial development and they had to put privacy slats in their chain link fence. Well, maybe they didn't like that. Maybe they didn't want to do it. Maybe they had an argument. They could actually make an appeal to the subdivision and development appeal board, or in our case, the intermunicipal subdivision development appeal board to appeal that condition. So they do have that right on a permitted use. Discretionary uses within a district may be suitable for that district. Typically they align somewhat, but there could be offset impacts that need to be considered by the Development Authority when considering a discretionary use within a district. So in this case, the Development Authority can either approve with conditions or they can refuse that particular application for discretionary use. In this case, decisions on a discretionary use can be appealed by both the applicant, either the refusal or a condition of approval, or adjacent landowners who are notified, as well as public or any agency that's notified on that particular approval. Council's a little bit familiar with direct control districts. They've been dealing with this district most recently, but these are another form of district that are within land use bylaws. There's two different kinds. I'll go over the open version first. So what open means is it doesn't really say open in the act, but what it means basically is a non-regulated direct control district. By non-regulated means there's no specific rules in place underneath that district. It's open for a landowner who has that zoning to come to council with a proposal for development. Council must consider that proposal against a whole bunch of things. One of them being statutory planning policy that's in place. Also, a whole bunch of different inputs in community or neighborhood conditions that might need to be contemplated. I know that sometimes open direct controls maybe get a negative context, and they're sort of like when you don't know what to do with a piece of property, you put it into a direct control open. I disagree with that. I think they're in the act, and the reason they're provided for as a tool in the act is because they're very helpful. Because there is sometimes certain pieces of land within municipalities that are just really hard to assign a typical land use district to. And this gives council the opportunity to consider any proposal, but also consider it with a really good community context. Because in my opinion, there's probably no body more equipped to apply community lens to a proposal than council. That's your role. So I think they serve a purpose and they are helpful in certain situations. You don't want them in too many of them, but they are helpful in certain situations, in my opinion. Decisions in a direct control. I'm gonna go to this. Actually, I'll speak to the appeal after I talk about the regulated first. So the other side of the coin is a regulated direct control, and we actually have one. DC-01 is within our bylaw. These ones actually look a lot like a conventional zone. They have uses. They won't have permitted or discretionary because they can't have a permitted or discretionary use in a direct control zone. They're all just uses. It'll have regulations that you typically will see in a zone about setbacks. It could have setbacks. It could have height restrictions, all kinds of different number of things that are applicable to a certain piece of land. Typically, they're driven by an applicant who wants to do something a bit creative on their land. Sometimes municipalities create them. They are a common tool. If you look at land use bylaws across the province, you'll see quite a few of these. In both an open direct control and a regulated direct control, they can determine who the development authority is. So it can either be council or it can be the development authority being the development officer. And sometimes it can be both. For example, in our open DCO, council is the authority on most everything, but what we did put in there is a provision for the development officer. I can't remember the specifics, I should have looked, but it's basically for simple applications. So let's say it's for a shed. We don't think it would be wise if a landowner wanted to put a shed on a property with a DCO and they had to come to council and go through that process just for something as simple as an accessory building on a parcel. So we put in a bit of a provision for, and that's pretty typical that you would see that in an open direct control. Any major proposal as council, maybe fences or sheds could be the development authority, the administrative development authority. So that can apply in both regulated or an open scenario. When it comes to appeals in a direct control, there is no appeal on a decision made by council. In the event where the development officer is appointed development authority, they may be subject to appeal. But the way the act reads, it's not quite the same as with a discretionary use in a conventional zone. It's more along the lines if the development officer rendered a decision that was outside of the direction of council. So I've never seen this applied, so I can't even give you a really good example of it. But I think it would have to be something the development officer did that was way offside that would probably be subject to an appeal in this case. So. Subdivision. There's actually two different pieces of legislation that govern subdivision in Alberta. There's Part 17, Division 7 of the Municipal Government Act, but there's also a regulation called Matters Related to Subdivision and Development Regulation. I'm not going to read all this, but I think what I'm trying to get across here is there's a lot of legislation and rules around subdivision and how subdivisions need to be considered, and how an authority needs to take a bunch of things into consideration before they render a decision on a subdivision. When it comes to appeals, it's a bit different as well. Unlike a discretionary development permit, adjacent landowners cannot appeal the decision of a subdivision authority. They are notified. If you look at the second bullet in the blue blocks, it says give notice to the applicant and adjacent landowners. That's simply a notice to say there's a subdivision that's been approved in your neighborhood, but they do not have the right to appeal that decision. The applicant can appeal a no, and they can also appeal a condition of that decision. And then when it comes to other appeal options, the government agency that's been referred to on the subdivision application can appeal that decision. Council may. Now this is really unique. I've never seen this in Alberta, but for a council to be an appeal authority, they would have to give the authority to render decisions on subdivisions to nobody in the municipality, basically. So maybe council appointed 5 members of the public at large to be your subdivision authority. In that case, council could appeal the decision of that authority. I've never seen that, but I think that's what this provision is trying to deal with. And then finally, a school board, with respect to those 3 points, may have the ability to appeal a decision of a subdivision authority. So going back to planning versus development again, just as a recap, council is working in this planning realm primarily with the community to create bylaws and policy about how they want to see their community grow. A little less appeal on this end, but there's lots of engagement. Typically, any planning policy or land use bylaw project will involve a lot of community engagement in order to get input from the community so council can make those decisions based on what they hear from their ratepayers. On the other side is the development side, which is primarily where administration does their work, with exception to a direct control application where council is identified as the authority. So just a reminder that there's those 2 realms. Something that comes up and it can be somewhat confusing is non-conforming versus non-compliant. So within the Act, non-conforming is defined. And essentially what this means is if I own a property, if I owned a piece of land 10 years ago and I built a house on it, I built it according to the rules of the previous land use bylaw. And it complied. I received a development permit that said, yes, you can build this house. It complies with the land use bylaw. You have an approval. It's on file. 10 years later, the town creates a brand new land use bylaw and the rules change. Let's say, for example, when I built the house 10 years ago, the minimum front yard setback was 5 meters. And so I built my house 5 meters from the front yard. Council, through that process, adopts a new land use bylaw, and in my district, it says the minimum front yard setback is now 6 meters. So my house does not comply with the current land use bylaw. So it's considered non-conforming because it does not conform with the current legislation or current bylaw, but it did at a certain time and was approved by the development authority. Non-compliant is very simple. It means that you never did apply for approval at any point in time against any bylaw, and you've added a use or a building without permission. So you're not compliant with the current bylaw or any previous bylaw.
Sorry, Councillor Posichny has a question.
Yeah, through Jim Kitlitz. Weird question on the non-conforming. So if I have a resident has using that setback example you just gave, and you have a house that's at 5 meters, and let's say it burns 80% of the structure, but your insurance company still wants to see you use the foundation, would you be able to get a permit to rebuild at the 5 meters, or would you have to move the whole foundation back 6 meters?
Yeah. I think the way, but this is with my next slide. So, you would have to rebuild it to conform to the new land use bylaw. Now, depending on, there's that last bullet there that I'll get to about the 75% destruction, but probably in that case, yes. If that's all that's left, it's the foundation, that's more than 75% destruction, you'd have to remove that foundation and put it back to the 6 meter. Yeah. So, the act also includes sort of these provisos when it comes to non-conforming uses or buildings. The first one's really interesting. If that use or building is discontinued for 6 months. So if, let's say it's a restaurant, the restaurant doesn't work out, they close down, and that building's vacant for 6 months and it was a non-conforming use, by the way the act reads, you would not be able to open up that restaurant at that particular location without redistricting, or you'd have to apply to redistrict. It would not be allowed. I've run into this a handful of times in my career. Really hard one to prove. What would have to happen is you'd have to make a point in time the day that use stopped, and you have to basically visit every day to confirm that it was actually not used for 6 months in order to make that stick. So it's there. It has a purpose, but I have never seen it actually apply or come to fruition. I'm sure. Like a pizza every 3 months. Yeah, exactly. Yeah. So, and that would probably would do the trick. So, interesting one. A non-conforming use may be extended in a building even if it's non-conforming. So, I'll use this building as an example. Let's say the north half was vacant, and this was a non-conforming use. Civic Center was our administrative building, was a non-conforming use. We would be allowed to extend into the rest of that building as long as we didn't enlarge that space. Again, I haven't seen this applied, but that is a regulation. A non-conforming use may not be transferred to other parts of or whole of the lot. So if this was a non-conforming site, we couldn't build a little portable office on another part of the property. That wouldn't be allowed. Non-conforming not be enlarged. So this was always the case. If it's a non-conforming building, it cannot be this. You can do renovations inside the building, but you can't extend the outside walls of the building of a non-conforming building. Something was added to the act. I don't know when it was. A few years ago, it allowed put a provision that the municipalities can add some provisions to their land use bylaw, which will allow a bit of flexibility on that, and ours does. We have a 10% variance on that. So, in the case of a non-conforming building, if a landlord did come in and say, "Gee whiz, I don't know, we want to add a couple feet to our front entrance or our bedroom or our kitchen because we got a brand new range," the Development Authority does have some room to allow a bit of a variance on that to expand it. It's pretty small, but it does help in some cases. To Councillor Precisione's question about the house that burnt down, the 75% destruction, if it's beyond that or greater, it must be rebuilt to conform.
Can I ask a quick question?
Yeah.
Sorry.
Yeah.
Just wondering, how common is it for us to have non-conforming buildings?
It's pretty common.
It is? Okay. Just as bylaws change and so forth?
Yeah, and it's
Okay.
pretty common across Alberta. Like a lot of municipalities face this. And that's why it's good to maybe not leave your bylaws for so long. Sometimes if you leave them for 20 years, you can really get a lot of that, and it becomes more and more challenging. We ran into a little bit of that with our new land use bylaw, and we did do some adjustments to try to minimize some of those impacts. So, but yeah, it's pretty common. The other thing I wanted to point out, this last bullet isn't in the act, but it's important to note that might be. This stays with the land. Doesn't matter who owns it. Doesn't matter how many times you sell this property. As long as it's non-conforming, it'll remain non-conforming until it becomes conforming with the land use bylaw, regardless of who owns it. Okay, off-site levies. So this is a big topic that we could spend a lot of time on, but I'm going to try to just give a high-level overview and a bit of a scenario on my next slide. So typically, offsite levies are major infrastructure that service more than one area of a community or larger areas of a community. We have an offsite levy bylaw, and we also have an amendment to that bylaw in 2013 or 14, I believe, which updated some of the math in it, and I'll explain that in a second. We also have a policy that supports that bylaw, and the policy just provides some exemption clauses that allow people to get exemptions from paying levies, and also a test of burden, I believe, is in there, where a landowner could make an application or representation to say they don't have to pay a levy on that property for some reason. So there's some mechanisms there for those exemptions. In my experience, the best practice is to apply offsite levy bylaws and offsite levies to greenfield development. And what I mean by greenfield is it's vacant, it's areas of expansion in your community, whether it be commercial, residential, industrial, and you apply it to new growth. That's not the case in Edson. Our model is to apply it across the entire municipality. I have seen this in other municipalities across Alberta. The graphic on the slide is actually from our bylaw, and as you can see, it divides the entire town of Edson into little levy zones. What do we call them? Zones or grids? I can't remember what they're called. Areas?
Levy areas.
Levy areas, yeah. Basically, the entire town's covered with the exception to the airport and our park spaces, and as well as the golf course, it looks like, is excluded. So it's not for greenfield, it covers the entire town in this case. So basically what an offsite levy bylaw is, it's a massive engineering study that identifies major infrastructure that's needed for growth of your community. It could be lift stations, it could be major sanitary trunks that cross town, it could be water reservoirs, major water lines,
Requirement for new wells to be drilled.
new wells, major roads, arterial collector roads, intersections. They're all kind of things that are offsite levies. Offsite levy projects, sorry. So that engineering study is done. It identifies all those levy projects, and then it creates an estimate of what those levy projects will cost. So there's 10 projects. The cost is going to be $10 million. They divide that $10 million across, in our case, these levy areas, and when you develop within those areas, there's a price per hectare value that you'll have to pay for your proportionate share of that major offsite infrastructure. So far, so good? That's following? Okay. One of the things that should occur is they should be reviewed every year. And it's not necessarily the bylaw changes every year, but what you're supposed to do every year is update your estimates. Because the price to build a piece of infrastructure in 2025 might be a lot more than it is in 2024. So in our case, the data was last updated in 2016.
Last review.
So I'm not a betting man, but I bet that a water reservoir, the cost to build a water reservoir in 2016, it's going to cost a lot more in 2026 to build that. So that's why it's important for municipalities to continue to update that data so that your levy rates reflect the true cost to replace or build that infrastructure when it comes time to build it. When do you have to build it? Well, typically what happens is they're within the levy, they're projects, and there's usually a trigger. So sometimes it's when a population reaches a certain number, you have to build a new reservoir, or when development reaches a certain area, you have to build in a lift station. So there's all kinds of triggers that will occur to determine when those projects get built. But ideally, these funds are supposed to be used to pay for those. One thing that's also important about levies is the accounting for levies is quite complex. There has to be an account for each levy, and they can't be used for anything else. If we collect money for a sanitary lift station, we can't 20 years from now say, we're not going to build that, so we're going to use this levy money to build a road over here. That's illegal, not allowed. We must use it for the infrastructure that we've collected it for. So it's another important nuance. So this isn't going to work that well because you can't see my animations. And please excuse the drawings. You know, I used to be a I started my career as someone who created custom maps and did a lot of CAD work, so I'm quite embarrassed about my work here in terms of this drawing, but bear with me. It's not about the mapping, it's about the example of how levies might work in a greenfield development.
Mayor Zahara has a comment for you.
I think we know why you were not successful in that path. Just kidding. Just kidding.
All right. So I'll tell my story about Kevintown, a small rural urban municipality in Alberta. So in Kevintown, there's this quarter section of land to the west side of the municipality, and two developers have bought the land and they want to develop this into a residential neighborhood called Greg Sean Neighborhood. And the developers have submitted an area structure plan to the town for approval that contemplates two residential neighborhoods with an arterial road bisecting the neighborhoods. And because of the size and the density of that development, they're going to need a lift station and some storm ponds and some stuff like that. So Alpat Developments is the blue up top, and then Core Peters the south one. So the way this works is the area structure plan identifies the growth and all the things that are needed to support that growth. Developers have to pay for all their on-site infrastructure. That's local roads, collector roads, sidewalks, curb and gutter, boulevard landscaping, parks, all the services that go towards those houses. That's all 100% borne by the developers. Off-site infrastructure, and in this case, they've identified that we need a sanitary lift station in order to get the waste to our treatment plant. That's not just for one developer, that's for that entire quarter section. So that becomes a levy project because it's benefiting more than one developer. It's to determine that the north half where Alpat Developments is, they can drain into the existing catchment area for stormwater, so they don't need any storm infrastructure. But Core Peter, unfortunately, they can't do that, so they're going to have to build a stormwater management pond to manage their water. But that's not a levyable project because it only benefits their half of the quarter section. The north half doesn't need that stormwater management facility, so therefore they don't have to pay any share of that. Typically, when it comes to an arterial road, and I'm talking about bigger arterial roads that you don't have here per se, but it's usually a 4-lane, so 2 lanes, and then later on another 2 lanes, 2 in each direction. Typically what happens is the developers will pay for the first 2 lanes as their development needs it, which could include large sanitary trunks that service more than that neighborhood. Because remember, there's going to be other development further west of this, of Kevintown, so, of Greg Sean neighborhood that may need that capacity. So developers are going to pay for the first 2 lanes of the arterial road. They're going to pay for they're going to pay for those first 2 lanes. If that arterial road has major trunks in it that service more than that community, those will be off-site levy projects. And then typically, the second 2 lanes of the arterial road are also off-site levy projects. So they're not built right away because typically what happens in a residential neighborhood is you only need 2 lanes for the first 10 years. And then once the developers have developed that neighborhood out to a certain density or a certain population, it triggers, well, there's enough traffic volume now, we need to build those second 2 lanes. And that's when the levy will kick in and pay to build those second 2 lanes. They're typically municipal projects that do the levy projects, whereas the developers are the ones building all of the other infrastructure that's on site. And so based on the estimates in the offsite levy bylaw, there's a per hectare cost for the developer to pay into the levy to pay for those offsites. So this little table here shows that a water levy is $18,420.16 per hectare. So every time a developer comes for a phase and asks to subdivide the land, they subdivide an area. If it's 10 acres, they're going to pay 10 times 18,000 for their water levy, and so on and so on as they develop that site. The levy gets built, and then when it's triggered, the offsites are added to the municipality's capital plan, and they build the offsite when it's needed. So that's in a perfect world, typically how offsite levies work in my experience. They kind of work the same way here in Edson. The only difference is they don't apply to greenfield development. We've applied them across the whole municipality, so it's not just new development paying for these offsites. The cost to build those offsites is borne by the entire municipality, with the exception of the ones that get exemptions. Questions on that? I know that's a lot. It's a long story, but any questions on that?
Councillor Pisichny.
Yeah, through Deputy Mayor Fogarty to GM Kitlitz. So prior to having offsite levies in the town of Edson, we had a situation, this is going through to council as well. We had people would come in, they'd find a large chunk of raw land within the municipalities. So for example, by West Haven School, and they'd want to build a large multifamily. And it didn't matter where you wanted to develop in town. There was always, the town engineers would always say, well, it's going to cost you this much, and then it would cost you that much. And they never had an idea of how much it was going to cost. And it changed, depends on who the developer was and what time they came in and who they came into. So when we applied the offsite levies to the entire community, because we had a lot of raw land within the town of Edson, it was not to go after the person who wants to build a garage. It was to go after that building, because I don't know how the city of Edmonton's doing it with their building eightplexes in single-family dwellings, because every time we wanted to increase densification in our communities, the first thing engineers say is, you don't have the infrastructure to handle the densification of that neighborhood. So if you allow a developer within your community to tear down 3 houses and put up a 10-plex or an 8-plex, you now have to fix that infrastructure. If you don't have offsite levies to apply to that, then in the future when you have to upgrade the sanitary systems like we're doing currently in the community, then it's bared by the entire municipality as a whole. It was also very frustrating for developers when we were growing very fast to come to Edson and not have a clue what their offsites were. People in our community were selling lands as if they were serviced. So people come to Edson and think they're buying service land, paying a large amount of money because they wanted to be in Edson because things were going. And then they're like, where's my water and sewer? And then the town would say, well, we don't have it there. There's no way we're going to get it to you. You want to pay for it? And then they're like, well, that's not fair, because we had no offsite levies plan. Without an offsite levies plan, you don't know what the greenfield, and the greenfield is you have no cost on that. Because people assume if it's within municipal limits, it has servicings. And unfortunately, people would buy stuff, not realize and didn't have servicing. So the reason is applied to the entire community is because we had a lot of large vacant spots within the community that could be developed into neighborhoods. As we saw, Wilshire was built at the time. There's neighborhoods, the raw lands, the North End had area structure plans, and we had areas that were building higher density housing. They had to pay offsite levies, and we didn't have any plans. So that's why at the time it was applied to the entire community, because we had a lot of, we had a lot of vacant lots, for lack of better explanation, within the community. So could it be corrected? I wouldn't disagree with it, but I just know, just maybe given the background of why at that time it was applied.
Okay, thank you.
Mayor Zahara.
So through to GM Kitlitz, thank you for all this information. I know you put a lot of work into this. So with the offsite levies, this is just topic of discussion that we've had a few times now. Do we have a plan moving forward, or is it just something that's kind of sitting there in the back burner of one of the projects we hope to get to eventually, to update those costs and update what that looks like in the future? Because I remember when we brought this in, I don't know, Councilor Pisichny, was like 10 years ago, 12 years ago, maybe more. I knew it was a lot of work back then. It's a massive project. It's like doing the land use bylaw again. So what is the plan moving forward?
Yeah, thank you for the question through your deputy mayor. So it is on our corporate plan. So one of the things that we have built over time is a list of all the projects and things we have to do to support council's strategic direction. So it's on there. I don't want to tell you when it's on there because I think it's going to change, but it is in the near future. We recognize that it needs to be fixed, but I think one of the things that was important is for us to get through the municipal development plan first. Because that body of work is gonna tell us, the council and the community, where our growth is going to be, if it's going to be anywhere, and how. And so then we can focus an offsite levy bylaw. And I'm not going to suggest that we don't have to apply it to the whole community. I think maybe there's rationale for doing that. But I think that exercise will help us determine with the help of the MDP and where our growth should go. It is a big pile of work, you're right, Mr. Mayor. not only is it a big body of work to determine what those offsites are and get those estimates and create the bylaw, but one of the things that I think is not concerning, but what I don't know, I guess, is probably an unknown for me, is one thing I didn't mention, I don't think I mentioned, is that once you collect a levy on a piece of property, you can never collect it again. So we couldn't collect a transportation levy on a property 10 years ago and then do a new bylaw and have a new piece of infrastructure and go back and say, hey, listen, you're developing again, we're going to charge you a transportation levy again. Against the law, we cannot do that. So you only get one shot at it. And so we've applied this across the whole community, and certain properties have paid a levy. And so when we redo it, what I think we need some help with, probably from legal, is how do we reconcile all of that and understand that we're not going to be able to collect levy from certain properties anymore. And so it's quite complex. It is a very complex project. It's going to take a lot of work. We're going to need some very good, professional help to get through it. But the complexity of what we do if we change it, those are some of the things I don't quite have a handle on yet.
Mayor Zahara.
Thank you for that. So when we first brought the offsite levy bylaw, I remember the arguments of the day were, it's going to stop development and all these sorts of things. And obviously where we are in the economy right now, there's a very big focus on the cost of development. And I've been watching some news articles in Toronto, for example, how much it costs for them to build a multifamily building, and the permitting cost for that is through the roof. In your experience, are offsite levies more common now in rural Alberta? Because I believe when we first brought them in, it was pretty sporadic. Obviously, things were a bit different back then than they are today. And today, municipalities are looking for any mechanism possible to help pay for the massive costs of infrastructure. And there is a thinking behind developer pays. It should not be borne on the taxpayers. So from your experience, are offsite levies pretty common in communities our size?
Through you, Deputy Mayor, unfortunately, I only have limited experience in rural. So my time in the Edmonton region, pretty common. Without question, every municipality in the Edmonton region had offsite levy bylaws for their greenfield development. The only other rural municipality I worked for did have an offsite levy bylaw, and it was actually the same model that we have here in Edson. So I don't really know for sure how rural municipalities are employing these, whether they're using them or not. So I don't have an answer for you. Sorry, Mr. Mayor. No more questions on levies? So one more slide. So just in summary, Council sets a policy framework through adoption of statutory plans and operational bylaws. The direction is set by Council through community engagement, hearing from your ratepayers and your citizens to set that policy direction. Administration implements those growth policies through subdivision and development permit applications. And the important thing is that the planning development process provides ample opportunity for public engagement and input. And it also provides mechanisms for applicants and adjacent landowners and the public to appeal certain decisions. And these are pretty common across Alberta. Like I said, this is the Municipal Government Act. Quite often I've started work in new municipalities, and there's always somebody in the municipality that's developing say, well, I've never had to do this in any other municipality. And that may be true, but the rules apply to every municipality. And maybe some municipalities don't administer exactly the same way, and maybe things aren't done where they should be, but the rules apply to everybody, and this is the way planning development services should be administered across Alberta as per the Act. So that concludes my presentation, high-level overview. If there's any other questions the councils have, Julie and I will try to answer them for you.
Anybody have any other questions? Mayor Zahara?
We, through to administration, obviously we passed our brand new land use bylaw about a year ago. I guess through our development officer, how has that been working compared to the previous bylaw? How has the feedback been in terms of people coming in looking for permits? And how has it been for yourself personally trying to understand the direction from council through that bylaw?
Through the Deputy Mayor to Mayor Zahara. So far, the land use bylaw works infinitely better than the last one. But we spent 3 years going through what didn't work with the previous bylaw. So, of course, on a daily basis, there's always things that we find, little nuances that maybe isn't exactly how we intended. It is why we internally scheduled annual amendments to come to council instead of, as Jim Kitlitz mentioned, waiting 20 years to fix anything. So the bringing them back annually and keeping a log of where we're finding deficiencies has been really helpful, because in keeping that log, we can see how often those same concerns pop up and whether they're a real concern or maybe just something that isn't ideal in this situation. One complaint or one concern about something in the land use bylaw isn't maybe necessarily the hill we're going to stand on top of, but if it's come up 6 times in 6 months, perhaps maybe that's the one we need to focus on, you know, what planning best practice is. I meet with people on a daily basis, and I actually do hear quite a number of nice things said about our land use bylaw and how it is helping some of our residents and some of our business owners bring their properties into compliance, and understanding what that compliance looks like.
Councillor Pichichny.
Thank you, Deputy Mayor Fogarty, to administration. Now, I know in community, we have people in the town who've built things or done things and never got a permit, and then they're non-compliant, right? Not
Yeah.
they're non-compliant instead of non-conforming. And then we have fees associated if you try to get that compliant that are generally fairly heavy. Is that correct? Or did we lower those?
Through Deputy Mayor, I think they only apply if we caught. Do we do double fees? Yeah, if you haven't applied, there's double fees, but I don't know that we're applying those in history, are we? It's more so if, let's say you started to build something today and we found out about it tomorrow. I think it's a double permit fee, correct? Is that what it is?
It does exist that way
Yeah.
on our fees and rates
Yeah.
bylaw.
I don't think we've applied it to go back 10 years ago. You didn't get a permit, so we're going to charge you double. I don't think we've applied it in that way ever.
So we ever thought about an opportunity kind of like the library does, where, there's once a year, once every other year, we say, hey, if your house is non-conforming, maybe as an opportunity, we waive the penalties or something to get you brought up to speed or something to try and get people who haven't got like permits for their oversized sheds or such. So I wasn't sure if we've ever entertained something like that.
When we looked at bringing the land use bylaw, the new land use bylaw into effect when we were repealing 2070, that is something that was discussed, having an exemption period for the double fees or even fees at all. It was more of a, if you're willing to work with us, we're willing to work with you and exempt an amount of our fees just to bring your property into compliance. But it's not something that we'd ever come back and gotten direction on.
Yeah, if I could, Deputy Mayor, I think before we started the land use bylaw project, I think I came and talked to council a little bit about sort of a 1 year sort of grace period where we could do that. I think where we see on a daily basis where the biggest challenges are is with business licensing. Sadly, I don't think the previous land use bylaw contemplated change of use permits, and change of use is something that happens quite often. But where the heartache comes in is, and I'll give you an example. I'm not going to be specific, but a young new entrepreneur in our community finds a space in a downtown building. They approach a landowner, say, hey, I want to lease 500 square feet off you to open up a nail salon for myself. I'm going to get into the business and start my own business. So they negotiate with this landowner. They get a lease for 3 years that pays whatever amount a month to this landowner. They come to us to get a business license, and we tell them, well, that's not a permitted use on that building. You need to get a development permit. Well, they've invested a whole bunch of money and time into to build a new business in this community, and now we've put up a roadblock, and they've got to go through a bunch more hoops, and they might have to delay their opening. And so it's for us, it's just sad to see that a young entrepreneur is is running up against this roadblock. But well, a lot of times, more often than not, the landowners never ever got permits to bring that property along into compliance with the uses that are on it. And so that's where it's really hard for us to try to stick handle that. So, you know, the idea of having sort of a 1 year bring your property into compliance period, I think is one that would be helpful, particularly when we start the business license renewals every year, because I think this year even we had some struggles with that. And yeah, what council could consider is maybe it's a $10 permit. You come in and bring your property in compliance, it's $10 for whatever you have, and we'll bring it into compliance. And but if you miss that 1 year grace period, if it's the next year and you're not compliant, well then maybe you're paying double or triple, right? So it's something we could do if it's the will of council to try to implement something like that. We could take it back and come up with sort of a strategy on how to do that.
Mayor Zahara?
Thank you, GM Kitlitz. I think you bring a really important point with our new business license bylaw, because some of the feedback I received was, you know, I've been in business here for 10 years and all of a sudden you're asking for all this information and landlords haven't done the things you've said that they should be doing. I would really like to see us put something like that in place to give those landlords and businesses the opportunity to be conforming, to work with them. That could alleviate a lot of heartache for us down the road as well as for them, and encourage, once again, part of our strategic plan that's going to be coming forward is economic development. Nothing is worse for business than roadblocks and uncertainty. And so if we can work with our business community, I think that's a good way of doing it. You know, we can have it there for a year. Obviously, there's capacity issues. We can only do so much in so much time. But if they're in the queue, then, you know, we can continue to work on that. So especially, I think there's already a 1 year grace period with the business license bylaw. So I think that's a good opportunity for us to do that and show that we are trying to work with our community. But if you don't take us up on that offer, then, you know, obviously you're going to have to deal with those consequences afterwards.
Okay.
Does anyone have any other questions? Well, I'll just take a minute to say thank you to you both. An important topic, but for me, an important topic to understand that we have good people with knowledge to guide us through it. So I want to thank you very much for that. CAO Beveridge.
Thank you, Deputy Mayor Fogarty. As is this committee of the whole, it'd be something we would bring back for consideration for council to make a full decision on with regards to what the financial implications of doing so and all of the full scope of what that could look like for our community.
Thank you so much. And thanks again. Appreciate it. All right, moving on. We have no closed meeting session, so I will call this meeting adjourned, declare the meeting adjourned at 7:53. Thank you all.